I kindly to mention upon notice, Lordship, I want gradation of item 28, Lordship, the urgency, Lordship, that I am the petitioner creditor and the 28, Lordship, last item, company matter adjourned, Lordship. Official equity is not taking any steps since the application is pending. That's why since April, this application is pending, April 2023 and 24, Lordship, and this no steps has been taken by official liquidator due to the pendency of this application.
Very well. Next Friday, I'll take up the company matters first. Before the next Friday, company matters will after the contempt matters.
Great.
যদি কোনো contempt থাকে তারপরে to be mentioned contempt, then company matters first. Next Friday.
My lord, this item is appearing at my instance.
Yes.
My lord, I am here, my lord, to pray for leave to file this requisition for completion and drawing up of the order passed by my lord.
So I need to give you a leave for.
Yes, my lord.
Leave is granted. Yes.
My lord, leave may be granted on the bottom of the requisition.
Wherever. Yes. একটা line order করে দাও. Leave be granted as sought for by learned counsel for the
award debtor.
For the award debtor.
Grateful.
Thank you.
Leave number 2.
Excellent. Leave B na. Leave is granted. Yes.
But a preliminary point, let him address and argue whether review is at all maintainable or not.
So you have to deal with that also. Take your seat, Mr. Dev. Yes, Mr.
I was primarily, my lord, trying to contend that possibly, my lord, there is some error on the face of the equipment. Your lordship will kindly not take me amiss, my lord.
Because you have filed a review application.
That order, my lord, substitution.
Yeah, should the court take you amiss for that, Mr. Gupta? Is there a presumption that the court should take amiss because you have preferred an appeal or filed it? Anyway.
Well, your lordship kindly takes the memorandum of review once, well.
Yes.
Where the order is there.
Right.
But just before taking your lordship to the order, in a nutshell, my lord, the brief backgrounds.
Please.
My lord, an execution application was filed of a consent award passed in 2009. The execution was filed in 2015. My lord, one of the
They filed the execution.
They filed the execution.
Right.
My lord, senior friends client. My lord, one of the award debtors whose name appears in the award had not been made a party in the execution. Now, my lord, after we pointed that out, my lord, after the period of limitation, they seek to add the heirs of that deceased award debtor as a party in the execution.
What was the nature of the award? Money?
Partly money, partly injunction. My lord, your lordship was pleased to allow that application of theirs on basically on two premises.
Adding those persons.
Yes. Their application was GA3 in the EC, which was for addition of these persons. It was in the nature of an order 1 rule. Your lordship has been pleased to add them as parties, primarily on two premises. Firstly is, my lord, that your lordship had indicated that my clients had deliberately taken up this issue post the expiry of the period of limitation. So we should not be permitted to take advantage of that. Secondly, on the ground that, my lord, section 21 of the Limitation Act proviso is there, which was not there in the previous section 22 of the old Limitation Act. Your lordship was pleased to condone this delay and treat this as from the date of the. Now, my lord, these are the two facets, my lord, of the order, which, my lord, I will try and satisfy your lordship that possibly these did not exist. My lord, firstly, on the ground that, my lord, we had deliberately raised this issue after the expiry of the period of limitation. The execution was filed in 2015, but I shall show from the documents and your lordship's previous order also recorded the same, that it was served on us only in August 2024. The execution application for the first time, though filed in 2015, was served in August 2024. Possibly that has not been taken into account in the order impugned. Your lordship will kindly consider this. And the second issue is, your lordship's entire reasoning is based on section 21 of the Limitation Act. In my humble submission and backed by some authorities, my lord, section 21 is not applicable to execution proceedings. So these are the two premises on which, my lord, I humbly submit that perhaps, my lord, there is some error apparent which warrants review of.
Right.
But if I may take your lordship today.
Please.
A preliminary issue has come up as to whether the execution case is barred by limitation, either as a whole or in respect of the heirs of one Aditya Vikram, one of the deceased award debtors. The brief facts of the case are that the award holder is a society in charge of Chatterjee International Center, a building situated in Kolkata, and the respondents are owners of certain portions in the car parking area of the said premises. Disputes having cropped up, the matter was referred to arbitration. Ultimately, in a proceeding before the division bench of this court, the parties agreed to terms of settlement, which was further reiterated by correspondence between the parties. Ultimately, the consensus was given final shape by an award passed by the arbitrator dated 19 February 2009. Alleging that the award debtors were not complying with the terms of the agreed award, the execution was levied under Section 36 of the Arbitration Conciliation 1996, giving rise to EC number 1016 of 2015. Now, may I pause here for a moment with my lord's kind indulgence? Your lordship will kindly see that from 2009 till 2015, it's already 6 years. So, my lord, I shall also demonstrate that, my lord, portions of the award had become time barred. Because, my lord, there are two articles which govern the execution applications. If it's a mandatory injunction, it's 3 years and not 12 years. But I shall take your lordship. Then may I read on, my lord? Paragraph 4. During hearing of the execution case, an objection was raised on behalf of the surviving award debtors on September 3, 2015.
But the limited point which was considered, Mr. Gupta, was apparently that whether it was time but due to non-implement of these heirs of Vikram.
Yes, yes.
So the general objection as to limitation which you are taking regarding mandatory injunction and all,
Well,
that was not a subject
yes.
matter of conciliation in this order.
possibly, my lord, there would be a conduit which I need to join, which is post expiry of the limitation period, no party can be added.
Yes, that was
So-
the conciliation here.
Yes. So I am saying that the EC itself, as on the date of institution, was banned.
That was not subject matter here, and you did not take that objection here. Because the limitation act,
I bowed. I
that
bowed out.
that
I
point is
bowed.
available even without implement of these heirs.
Yes. That is otherwise also available when I'm opposing the EC.
Right.
I bowed out.
Right.
And I'll not labor. Grateful. Well, then may I take your lordship directly to, my lord, paragraph 5.
Yes.
When the application was being moved, the award debtor specifically took an objection that the execution case has become time barred at least as against Aditya Vikram and his heirs, since the application for implement bearing J number 3 was filed much beyond the limitation period of 12 years for enforcing the award. It was alternatively argued that the execution case had become time barred against all the award debtors in view of the award being non-severable between the heirs of late Aditya Vikram and other award debtors. 3 judgments were cited, which will be discussed here. Then the next point. The award holder disputes the said proposition and argues that what remains for execution is primarily the injunction component of the award, which is a recurring and continuous cause of action. Thus, limitation does not apply. Moreover, it is argued that the objection as to non-joinder was not taken at the earliest possible opportunity and as such cannot be entertained at this belated juncture. But may I humbly pause here for a moment? These are really the two issues. One is a recurring and continuous cause of action, and the second is objection not taken at the earliest possible opportunity, both of which weighed with your lordship, and on this premise, your lordship was pleased to allow the application. An analogy has been sought to be drawn with Order 1, Rule 9 of the Code of Civil Procedure, the proviso to which stipulates that the rule which provides that no suit shall be defeated by reason of misjoinder or non-joinder of parties shall not apply to non-joinder of a necessary party. Late Aditya Vikram being one of the award debtors and thus a necessary party, the award debtors urge that the execution case is barred by limitation against him and his heirs, if not against all the award debtors, since the award is non-segregable. However, there is a fallacy in the said argument. It is well settled that a technical objection as to non-joinder of a necessary party is required to be taken at the earliest possible opportunity in order to enable the dominus litis or the plaintiff to cure such defect. Courts have held time and again that the said defect is curable and a suit ought not to be dismissed merely for non-joinder of a necessary party without granting an opportunity to the plaintiff to cure such defect. Such proposition finds support on a composite reading of rules 9 and 10 of Order 1 of the Code. Sub-rule 1 of Rule 10 empowers the court, if satisfied, that the suit has been instituted by omitting a necessary party through a bona fide mistake, and that it is necessary for determination of the real matter in dispute to add a plaintiff to do so at any stage of the suit. Sub-rule 2 of Rule 10 provides that a court may at any stage of the proceedings, with or without an application by either party, add any party to a suit. It would be an unnecessary curtailment of such power of the court if the defendant in a suit are permitted to take such objection deliberately at a stage when the limitation period for levying execution has expired. The execution case was instituted within the limitation period as provided in Article 136 of the Schedule to the Limitation Act 1963. And if it was pointed out within the next 5 years, the award debtor could very well have cured the defect by impleading the heirs of the omitted award debtor in time. Having not done so, in all propriety, the award debtors ought not to be permitted to raise such an objection at this belated juncture. My lord, apropos this, my lord, may I show the previous order passed by your lordship in this execution application? My lord, if your lordship kindly takes the application for review, my lord, and takes a look at page 59.
Yes, 59.
Well, this is an order dated 5th of August 2024.
Right.
The date would be of some relevance, my lord.
Mhm.
59. The learned counsel appearing for the award debtor, who was also one of the joint special officers appointed in the matter, submits that no copy of the enforcement application has been handed over to him. Accordingly, the award holder is directed to serve a copy of EC such and such on the learned advocate appearing for the award debtor by tomorrow. So for the first time in 2024 August, that the execution application was served, despite them being obliged to serve as per Order 21, Rule 22, because they put the award in execution after 2 years.
But this was not an adjudication that it was not served before. The learned
No, it was
advocate,
never served. But
They
they
have to
also
show it.
they also did not had never shown anything to show that it was ever served before. The EC,
I will argue on this. Accepted money, material sold,
the EC was never served. There was a GA
absolute incorrect submission.
There was
GA
a
in
GA
correction, in
with the
connection,
EC, but the EC was never served. There was a GA in
you had
connection.
knowledge of the EC then.
No, I had knowledge that an EC has been filed,
In
but
a GA, the EC must be quoted also. And if it is in connection with the EC, it must be stated there that it's in connection with the EC, with an EC.
it's in connection with the EC, but the EC
So you
was
know,
not
come to
served.
know about the EC pendency of the EC, and
Yes,
it's your
EC was never served. It was only a GA.
service is not important. The copy of the application for execution is not important. Mr. Gupta, your knowledge about the pendency of the execution case is important. It's your onus also to appear there and move the matter or contest the matter.
But we had contested the GA.
GA, you knew in the GA it was disclosed that it is in connection with an EC, and therefore you immediately have knowledge that there's an EC in connection with which the GA has been filed. So it's your burden then, your onus then, your prerogative rather, to appear in the EC and take whatever points you have
EC
to
was
take.
never taken up for hearing. EC never appeared in the list. It's
Even in
only
the
the
in
GA.
connection with the GA, if
It's
a
only
GA
the
is filed,
GA.
if a GA is filed in connection with an EC, then in that GA also you have to take this point that the EC is not maintainable, so GA in connection with it is not maintainable also. If you appear in connection with an injunction application in a suit, in that injunction application also you can take this point. The suit itself is not maintainable, so this injunction is not maintainable also.
In the GA, the EC was not annexed.
May not be annexed. The
Yes.
application itself, the tabular statement of the application may not be annexed, but that's a formality. The EC has been levied, you know that.
Yes.
And if you know that it's time barred, you definitely have an onus also to appear there and take those
No,
points.
I'm not on the issue of time, but my lord, I am on the issue of, my lord, whether the whether a necessary party who was a party to the award
No,
was
you
made
are
an
on a
argument.
point that you had not taken this objection at the appropriate time.
Yes.
That is the point
Yes.
which
So
we are hearing now.
immediately when the EC was served, we had taken
EC
the
was served later,
Wha-
but you had knowledge of the GA. They only have to show that at least you had knowledge of the pendency of the EC within that limitation period. That much.
But I'm sorry, my lord, I have to interrupt at this stage, my lord. I'm sorry, my lord. Sorry for troubling him. An absolute incorrect submission. There's an order passed on 13 January 2021 just by Justice Bosha.
That is also annexed probably. I saw Justice Bossak's name somewhere.
And that order, Lordship would see EC and GA both are appearing. And why that application was filed? Because some of the judgment
have
debtors passed away.
61.
That's a different thing.
The
Some
next-
of the judgment
the
debtors
next-
passed away. What is he saying, my lord? What is he saying?
You have to explain what you were saying.
Yes. My lord,
Anyway, this is your point that EC was never served.
EC was never served on me.
All right.
Like, may I place this order also?
Mhm.
My lord, accordingly, the award holder is directed to serve a copy of the EC on the award letter by tomorrow. Learned Counsel, I'm not placing that. Then, my lord, the order which my learned senior friend had placed. Kindly see page 61.
Hmm.
My lord, this is, my lord, with respect to some respondents who were arrayed as parties who had died. The learned advocate appearing in support of the application submits that some of the respondents died. Learned advocate appearing for the surviving respondents submits that the particulars of the death and heirs of the deceased respondents were provided to the learned advocate appearing for the petition. Learned advocate appearing for the petitioner seeks adjournment, then the matter is on submission. This is an order which is passed in the GA, which was contested. There are several orders in the GA, which is for sale of certain movables in the building and for some tiles which were installed in the outer facade of the building. And all along, the GA was what was taken up for hearing. EC was never served. Then if your lordship kindly sees page 63. This is the first time upon service of the EC when we appear before this court in the EC. Learned counsel for the award debtors point out that heirs of Aditya Vikram, one of the original award holders, have not been included in the execution application, thus rendering the same bad for non-joiner of necessary. So, on 5th of August, it was directed to be served on the next day. On 19th of August, we had taken this objection.
All right.
Now, my lord, your lordship was pleased to, my lord, in the order under review, was pleased to, my lord, rely on, my lord, section 21 of the Limitation Act. But if I may place the Limitation Act section 21.
See, Limitation Act.
May I?
Please. Thank you. Yes. 21.
Effect of substituting or adding new plaintiff or defendant. But here is not a case of a plaintiff or defendant first. Second is, my lord, may I place subsection 1, where after the institution of a suit, specifically mentions a suit, a new plaintiff or defendant is substituted or added, the suit shall, as regards him, be deemed to have been instituted when he was so made a party, provided that where the court is satisfied that the omission to include a new plaintiff or defendant was due to a mistake made in good faith, it may direct that the suit as regards such plaintiff or defendant shall be deemed to have been instituted on any earlier date. Subsection 2 is not relevant for this. Now, this proviso has been added. Now, your lordship will see that, in the definition section, section 2, suit has been defined in L, 2L.
Yes.
Suit does not include an appeal or an application. And my lord, I am backed by authorities to show that, my lord, execution application has been specifically kept out of the purview of this section. And also your lordship will kindly see 2H, which is good faith. It is defined. Nothing shall be deemed to be done in good faith, which is not done with due care and attention. My lord, now section 21, the proviso, which, my lord, possibly weighed with your lordships in delivering the judgment, required that the mistake had to be in good faith, which would give them the benefit. So, I shall try and satisfy your lordship first that 21 does not apply to execution at all. Okay. If I may, but firstly, I've shown that definition, my lord. Secondly, my lord, your lordship will kindly also see the language of, my lord, other provisions where suit and applications have been spelled out clearly in the in the Limitation Act. Kindly see my lord, section 15. If your lordship kindly sees the language of my lord, section 15. Your lordship will find that it says that of any suit or application for execution of a decree. That's a specific, my lord, language is. Now thereafter, my lord, your lordship will also see 17. It also says suit or application. Same is there in 18. So, my lord, what I was humbly submitting is, my lord, section 21 cautiously omits any application to be given the benefit of this provision. Now, may I please, my lord, a judgment of this honorable court, my lord, reported at, my lord, 2000 All India reported 2010 Calcutta, page 138.
Yes.
My lord, paragraph 24, if my lord is pleased to take up. It begins with
Yes.
the words application and suit.
Right.
The words application and suit have been defined in section 2B and 2.1 of the Limitation Act as follows. Application includes a petition. Suit does not include appeal or an application. Both are judicial proceedings. The word proceeding refers only to a complete remedy, but also to a step that is a part of a larger action or special proceeding. The definition proceeding is given in Black's Law Dictionary that has been quoted. Then, my lord, your lordship will kindly have a look at paragraph 28.
26 is also relevant.
26, yes. From the following, there are two broad categories of proceedings. First, a proceeding which is the entire course of action, and the second, a proceeding which is a step ancillary to or taken in course of the first. A suit is a complete independent proceeding falling within the first class of proceedings. Applications according to the Limitation Act are governed by Article 118 to 137. Characteristically, they are in connection with or are ancillary to a suit, its decree or execution. They are not in this sense an independent or a complete proceeding. An application in the sense used in the Limitation Act thus falls within the second class of proceeding. Then it's paragraphs 28 to 30. The next. Doctor will kindly give. Same জিনিসই তো বলছে। So, my lord, in execution, my lord, this provision will not be applicable.
Mr. Gupta, section 21 is not applicable. Then proviso is not required. The main body of the subsection 1 is also not applicable.
Yes.
Section 21(1) is the provision which says that it will be deemed to be from the date when he's made a party.
Yes.
That also goes.
So I
That fetter also
Order
goes.
1 Rule 10. Order 1 Rule
Order 1
10.
Rule 10 also deals with a suit, not an execution proceeding. The language of Order 1 Rule 10 is suit,
Yes.
which is equally applicable by your logic.
Yes.
So neither Order 1 Rule 10 nor Section 21 are applicable to an execution proceeding. If Section 21 is not applicable, the bar under Section 21(1) is also not.
So, when the limitation period is provided?
No, then this provision goes that after institution of an execution proceeding, if a new party is added, that execution proceeding as regards him shall be deemed to be instituted when he is so made a party. There is no equivalent provision then for an execution case. Because Section 21 is the provision which says that if a party is impleted to a suit, the date of his addition will be deemed to be that date,
Yes.
date of the order.
Yes.
Then that also goes. If his section 21 is not applicable to an execution case, then this fetter also goes.
Yes. But what I was trying to draw,
Proviso is not required by them. The main body goes.
the main body goes. So what I was trying to draw the distinction at,
I accept your contention. This contention is absolutely correct. But then section 21, that bar is not applicable to them. That it has to be from that date when he's added.
so when the limitation period would having expired,
Hmm.
then they cannot add a new party, because there, if it's past 12 years,
Right.
if I take the limitation period to be the highest, because I am not considering section.
So against that party, it was barred.
Yes, and if it is barred against that party, then the entire thing goes,
All right.
because it's a necessary party, because it's an undivisible and not a decree which is capable of segregation. So that is why this would go.
Hmm. Hmm. All right.
Now, yeah, whatever authorities we had placed on that occasion,
Yes.
those were distinguished on the premise that
Hmm.
on the premise of section 21.
Hmm.
So, if I may try and reiterate those
Mhm.
subject to my lord's kind consideration.
Hmm.
That, na, imbi not na, judgment gulo. First round is judgment. But then I'm not laboring on the definition and the authorities on good faith, because if 21 is not applicable, proviso is not applicable, proviso is good faith. Because I would have otherwise argued also that their application says by oversight. So, and already an award debtor who was there
Make
in
that
the
argument also. Make that argument also for completion.
very well.
Because
But
if
then
I
you-
fall back upon, I mean, I don't accept that ultimately.
understand.
Because these are discussions going on in court.
Yes.
So we are still fluid,
Right.
both of us.
But if your lordship kindly takes a look at section 21 proviso,
Yes. Good faith.
good faith.
Seen that.
And it is only when good faith is there, then your lordships would have
Yes.
the would condone.
Power to, yes.
Yes. Firstly, why I say that they
Can you make a half-page written notes later on file?
yes, yes,
Because I need the judgments to be in one place.
yes, absolutely.
Yes.
First fact on lack of good faith is they were already parties to the award. So when they file the execution, they ought to have made the award date.
Today I'll have to sit till, I'll be sitting till 1:40, 11:40, 11:45. I'll have to leave for profession for my some work. So try to finish within that, and so that he can, Mr. Dev can also try that.
Yes, yes.
It's a review ultimately, so be
Yes,
short.
I shall be as brief as possible.
Yes, yes.
Firstly, it's an execution application. The award mentioned the name. Their pleading with regard to why they missed out was oversight and inadvertence.
That is not good faith.
That is not good faith. And I am carrying authorities on this thing, that what is good faith.
Hmm.
If your lordship kindly permits me to place two authorities on that proposition.
Yes.
One is আর আমার এখানে বক্স স্পেসটা আবার অন্য খুলে গেছে বলছে না দেখানো তো this is reported at 2000 volume 2 Calcutta High Court notes, page 649 640. All these were marked, but the
What happened to the marking?
I don't know.
What is the app?
This is liquid text, but
Liquid text.
চামারটা
আচ্ছা,
পাচ্ছি
এখন তোরটাই।
But 115, if my lord is pleased to take a look. না আরেকটা চলে গেল কোথায়? Not 115, kindly if you can think about. But 114 quotes my lord Order 1 Rule 10, then also Order 1 Rule 10(5). The above provisions make it clear that the ordinary rule of relating back of permitted amendments to the date of institution of a suit is not exactly applicable to such amendments which have the effect of adding parties to the suit. It is unfortunate that the parliamentary draftsman in the amendments of the Code of Civil Procedure 1976 missed two limitation acts in Sub-Rule 5 of Order 1 Rule 10. But the mistake is not material in view of the provisions of General Clauses Act. What is material for our purpose is the purchasers did not come on record until 13/6/1994 when the amending order, including addition of parties, was passed by order number such and such. Then, in so far as kindly comes to paragraph 141. Good faith একটা শুধু কোথায়? Or it's not working. And 141. In answer to this, Mr. Such and such gave us the first case of Kapura Swami reported at 1993 SCC 41. He drew our attention especially to paragraph 4 of the judgment. He showed therefrom that the court ruled the proviso to section 21(1) as a beneficent one. He also emphasized that the change made in Limitation Act by adding of proviso to subsection 1 was found by the Supreme Court to have made all the differences. The Supreme Court said that only the court's satisfaction upon proof breathes life into the suit, which might otherwise be dead. Such satisfaction should be on proof that the inclusion of the right defendant by substitution or addition was just and proper, the mistake to sue initially having occurred in good faith. Thus, the important point to consider is the point of good faith, the point of lack of notice, the point of not suing the right defendant simply because the facts were not known, and not on the motive, say, of embarrassing the defendant later on by adding him as a party in a suit which has already gone on for a long time, allowing the left out party to change his own position irretrievably. The next case cited by relied upon by Mr. Such and such was in the case of Deepchand, the division bench judgment of our High Court reported at such and such. That was a case of addition of plaintiff, and such addition was vitally necessary to the suit for specific performance. The court ruled that orders for addition of party are ordinarily be construed as dating back the suit, as otherwise the order would be a meaningless order serving no purpose, since the suit is bound to be dismissed notwithstanding that the addition of right party has been made. Then when it's 2007, volume 11, Supreme Court cases 407. This is on the point that no care and attention would mean that there is no good faith. But I shall be placing reliance on paragraphs 9 to 11. Paragraph 9, whether an act. 7, volume 11, Supreme Court cases 407. Paragraph 9.
Good, yes. 9.
Whether an act has been done in good faith would depend upon the factual scenario. In order to establish good faith, it has to be established that what has been imputed concerning the person claiming to be so is true. Good faith, according to definition in the General Clauses Act, has also been given, and anything done without due care and attention which is not malafide is presumed to be done in good faith. But here, A, they had the knowledge and they cannot feign ignorance because, my lord, they were already parties to the arbitration and the award. They are the named award debtor.
They knew that he was a party, but they might not have known his death.
No. They were not made parties at all in the execution.
Oh, yes. Sorry. Right. Right.
Now, my lord, the second issue which just now fell from your lordship, that they might not have known about his death. That also, I say that they had knowledge. A, they are the society and not somebody else, not a third party. B, there was a paper publication with regard to the death, which we have managed to find out Page
What is the
64.
context of that paper publication?
But their knowledge.
But this is not apparent. You cannot go into. Cannot go into that question in review.
But because your lordship
There was a
had,
paper publication is a new fact, and it's not a discovery of a new matter. It was already there. So that probably
we
cannot.
did not, well, when the judgment was, your lordship will kindly appreciate one thing, with utmost humility, may I say, this was taken up by your lordship on the last matter before the puja vacation. Both of us appeared online. So we did not had the really could see, and the judgment was not delivered in the.
Which is a good ground for review.
No, the judgment was also not delivered, so we did not know that on the good faith aspect that was there. So what we had
You have to
managed
show
to
that
find
there's
out.
an error apparent on the face of. Till now, your arguments are on error apparent on the face of report.
Yes, but only.
But the
only
moment
thing
you say
because
there
of
was
the
a
good
paper
faith.
publication and all,
And they are the
beyond that.
society. They being the society, and also, but I possibly need not traverse to that higher pedestal that the date of death was not known to them. They were not even made parties. That is when
the predecessor, the person who died, was not even implicated.
who was the party to the award. So that is the lack of good faith. And your lordship will kindly see the averment. I shall only trouble your lordship with one paragraph in their application for addition of party. They say in paragraph 3 that they could not be made a party as respondent in the aforesaid execution case and application due to oversight and bona
It's a
fide.
part of this.
Yes.
Which page?
Page 74 of my application.
Yes. Yes. And bona fide mistake also.
And bona fide.
So bona fide is
This
good
bona
faith.
fide,
Bona fide is good faith.
bona fide could have been a good faith.
Yes.
But that pleading had to be supported by cogent documents or evidence, which in my humble understanding, subject to my law testing it, of course, is lacking here because they cannot claim bona fide mistake, he already being a party. So if this is not applicable, then proviso is also not applicable.
All right.
This is apart from my argument that 21 is not applicable. Yes. One other thing, good faith has to be pleaded specifically.
Bona fide.
But yes, but this is not a pleading.
Did not be in language good faith.
Yes, but this is not a
They can
pleading.
paraphrase the law and
But paraphrasing the law won't do it. It has to be supported by facts.
if
That
one
why-
says I had good faith, does not have it, that's meaningless. They have to plead it. Rudiments of pleading must be there. We cannot be too stringent on that. Good faith, these words have to be there.
No, I am not on that. But I am
They have
saying,
said it was a bona fide mistake. So pleading is there.
yes. So whether this mistake your lordship would construe as a good faith is what your lordship would have to see in the facts of the case.
Yes, which takes us beyond the domain of review. That is that I am constantly battling that limitation of yours. I'm
Yes,
trying to
but
be
the
with
only
you
thing-
because
yes.
you are arguing. I mean, you are arguing means the petitioner is arguing,
am.
so I'm with the petitioner for the time being. But even then, we cannot test the limits of review. So we have to be within that. Even if it's a legal error, I cannot correct that in review.
I understand. But the
Unless
only
it's apparent.
yes, but the only thing, your lordship will see that this good faith issue, possibly your lordship had not considered and had not considered from the aspect of my learned senior friend's client, what has
It's a
help
reopening
us
of the issue. They have said they are bona fide. I have mentioned in my order somewhere that they had good faith or whatever, bona
yes,
fide.
but your lordship had
That's a factual appreciation of the court.
yes, but
which
your
we cannot
lordship has
open.
considered
Yes.
that they were already parties in the application, and your lordship had held us liable that we have not pointed out to them.
Regarding the
is where-
death. No, regarding the objection not being taken.
Yes, but that is why I say that this is perhaps an error apparent because they were already parties which perhaps your lordship had not considered in granting them the benefit of the proviso.
All right. All right.
So this is where I try and
Very good.
now if your lordship kindly takes a look at section order 1 rule 10(5).
CPC ছোট বই আছে ওই বিরাটটা দিয়ে দাও। Yes. আচ্ছা সিপিসি ছোট সাইজের সিপিসি জন্য Yes, I have this.
Order 1 rule 10(5).
5, yes.
subject to the provisions of the Indian Limitation Act 1877, section 22, the proceedings as against any person added as defendant shall be deemed to have begun only on the service of the summons. A, this refers to proceedings. B, possibly service of summons can be juxtaposed with the service of the tabular statement and the execution application, and not service of any interlocutory application in connection with the main proceeding. Because otherwise, service of summons would not have been mentioned here, where the legislature is
Here the execution was not levied within 2 years.
no, it was levied after 6 years.
All right.
But it is another argument of mine that execution itself was time barred, because mandatory injunction of mandatory
Not that if it's after that period 2 years, they have to give a notice. So it can be
they have to give
equivalent to
notice.
summons.
Yes, because section 21, I'm sorry, order 21, rule 22 language is that.
Yes, it is.
So possibly, this can be juxtaposed to mean execution application as well.
And 36
this-
applies 21 squarely.
Yes. Now, your lordship has been pleased to, in the order impugn, was pleased to, negate the contention of order 1, rule 10(5) in view of 21.
Right.
If
21 goes,
if 21 goes,
then
perhaps then this your lordship will kindly consider this.
all right.
Now, in respect of this, we had shown 2 or 3 judgments which were again, distinguished on the ground
That line.
Yes. Now, if I may.
But Mr. Gupta, there is one difficulty. You just because it's coming to my mind. If we read order 1 rule 10(5) into an execution case, because this is also in connection with the suit, right? So if you read that into an execution case, then you also take it as a whole. If you take it as a whole, this applies, 5 applies section 22 or section 21 as it now is. So because the language of 5 is, this is subject to the provisions of Limitation Act.
Yes. So
So
subject.
if we apply this, we have to apply this as a whole, the principle as a whole. Then 21 again comes in by the back door.
21 cannot come in because it
You
21
cannot say that
restricts.
order 1 rule 5, order 1 rule 10(5) applies, but sans 22, because 5 is, it starts with 22. It's an, inseparable part of order 1 rule 10(5).
Yes.
Because it starts with subject to provisions of section 22 or section 21, as you say. This.
Yes. May I humbly try and
If we take this, we have to take it with 21 or not at all.
possibly I'll try.
Order
try
1
to-
rule 20, order 1 rule 10(5) is also not applicable to an execution case, Mr. Gupta.
But there was one judgment possibly which I'll
If we take that judgment, then order 1 rule 10(5) principle we have to take as a whole with 21,
But-
and your argument on
But
21
this
goes
is-
there.
This is where I'll try and satisfy your lordship in my humble way, that possibly that 21 cannot go with this, cannot come with this. Why I say so is subject to provisions of section 22 or 21. We should read it as 21. Now that provision is not applicable to execution. Subject to
But
the
order 1 rule 10 is
order 1 rule 10 is
applicable to execution.
applicable to
See the
execution.
language of order 1 rule 10.
Yes.
Order 1. Let us see the
Suit.
language.
Heading of the language is suit. I'm sorry, heading of the sub rule is suit.
Everywhere it suit all the way.
Yes, but only in 5. Only in 5, the
Hmm.
lordship will see the language is proceedings.
It speaks about plaintiffs and defendants in a suit. Order 1 itself is that. It does not conceive even of a order 21.
Does not conceive.
No,
But-
it speaks about a suit, about plaintiffs and defendants. The entire story, the ecosystem of order 1 is of a suit. So we cannot go beyond that ecosystem. If you take that ecosystem, 5 is a part of that. So if order 1 rule 10(5) speaks about a suit and says that subject to section 21, this will apply to a suit. If you take the principle of order 1 rule 10(5), no objection, we can take that, definitely import that into an execution case. But then the principle has to be taken as a whole. We cannot segregate at our suit will. We cannot say that this part of order 1 rule 5 principle will not apply and that part will, because it starts with subject to.
But the way I was reading is,
If we take order 1 rule 5, order 1 rule 10 5, then it has to be subject to the principle of order 21 also.
but here what I was humbly reading this as subject to 22 means if 22 excludes something, that exclusion would also come in.
You cannot
Because
you
22
cannot humbly submit that. You have to be very brash to say that I'll take a part of the principle and not the other part.
No, but I'm
You are going against the legislative intent.
but
Yeah.
if 20
Humility does not go with that.
but if 21 specifically restricts it to suit and not any other application.
Order 1 rule 10 also specifically restricts this
But-
principle to
Yes,
suit.
but 10.5 is proceeding. The language is proceeding, which is not there in the other
All right.
rules. So this is where I was trying to and I shall come back on this and try and satisfy your lordship on this, because this is where possibly your lordship's conscience is freaking that whether
My
both,
conscience always pricks.
no, that whether both would be there or not.
Right.
Whether this would go hand in hand or nothing would apply. So in just thinking on legs, I am
No,
not
this
backed
is a
by
very
any
interesting
authority.
argument.
I'm not backed by any authority, and
Need
I-
not.
and I would try and come back with any on the next day.
It's lawyers who make new authorities, Mr. Gupta.
Still, I'll try and
We just quote them.
find something to back my argument.
Yes.
If your lordship
You
kindly
don't
permits.
require an authority if your argument is sound.
Right. But my only argument is that because of the language, and it carves an exception with respect to proceedings, and because 21 excludes other applications, so subject to section 21 will not affect the petitioner's rights here.
Hmm.
Because subject to is execution won't apply, so this also will not apply. So this 10.5 subject to 21 can apply to suits. But subject
Yes,
to
it's an
21,
interesting distinction, deviation. What
your lordship
proceedings,
can see that
proceedings is.
but 10.1 kindly see it's a suit. Whereas
Everywhere it's a suit, but you're right.
everywhere is a suit.
5 uses proceedings.
Proceeding. So this is where possibly this
Alright.
is
All right.
the other thing your lordship will kindly also consider. That the proposition which
Sir, but Mr. Gupta, even then, you are trading on dangerous territory, because if you say that 5 deals with proceedings, 5 deals with proceedings and imports section 21, then whatever I said applies again in full vigor. Because if 5 deals with proceedings and says that regarding proceedings 5 principle will apply subject to 21, then 5 itself is the provision which imports 21 into 5.
but
into
21
proceedings.
that importing provision is not applicable to other
If 5 deals with proceedings,
yes.
independent of suits also it can apply. If 5 applies to proceedings as opposed to suits, then 5 has to apply as a whole. It speaks about proceedings. In proceedings, this fetter is applicable subject to 21 then.
Yes. Here I try and draw the line.
You cannot cull out one from the other. You cannot distinguish one
But
from the other.
I'll try and
Very-
satisfy your lordship
I
on
would
this.
also consider Muller 2 about proceedings, since he's harping on this.
No, here the
Yeah,
statute is
interchangeably
specific-
used. That's true.
Statute is specifically saying proceedings or application. Proceedings or application is the specific language of the
Very well,
statute.
very well. I take care.
But why I say that 5 can be imported without 21 is 21 specifically say suit. 21 carves out applications and executions.
All right.
So when 21 is coming, applications for executions are not coming. So 21 one proviso is not coming. If
Your
20
argument is accepted, either we have to say that order 1 rule 10.5 speaks about only suits because it's importing 21. Either we have to say that it deals with only suits because 21 is, inseparable from 5. 21 is a part of 5. Subject to 21, this happens.
Would your lordship kindly permit me to impress upon your lordship to think it in a different way, only for once.
I've thought it from 3 perspectives. One is that 21.5 speaks about a suit, although it states it's a proceeding because the rest of the provision is suit. If that be so, that is the only window through which we can import 21 as per your other argument, because 21 applies to suit only. The other way I thought was that it can apply to any proceedings. 5 can apply to any proceedings. If we proceed by that route, then In respect of proceedings, 5 deliberately and intentionally the legislature imports 21 into proceedings because 5 deals with proceedings. These are the 2 ways I thought.
Malad,
You
the
are
second
showing
way,
me a third way.
Malad, second
that-
way is where Malad, I also submit
If that be so, then
with
proceedings.
a corollary
All right.
that whatever is being imported
Hmm.
under 21 is for suits exclusively, because 21 excludes operation of the execution.
All right.
So one which is excluded cannot be imported.
Well, what else? No, take your seat, Mr. Dev. Nothing.
If I may come back on some other, because I
No,
need,
continue.
I would try
But I
to
would take
Every time could ask a question, you have to come back then. No.
Malad,
I'll ask all sort of questions whenever you come back. So whatever you cite, I'll ask some question or the other. You cannot come back on everything. No, no.
but
Conclude your argument, sir. And review application. No, further. What other point?
Yes, you can.
Yes. But even if then, yes, I'm grateful to my learned junior. So Lordship also sees section 21 language,
Yes.
which
Section 21 speaks out suit.
yes, and it says adding a new plaintiff for a defendant. It is not a case of a new plaintiff for a defendant. They were already parties. So this entire section will not come in. This is subject to 21. 21 is applicable for a specific, there's only species, a particular species 21 would apply. So this is where possibly, subject to my lord's interpretation of this, that since it refers to new plaintiff or defendant, it cannot come in an execution.
Not good. One says where after the institution of suit, a new plaintiff or defendant is substituted or added.
Yes.
Substitution means here's predecessor was there. So it takes care of both order 22 scenario and order 1 scenario. Substituted or added, Mr. Gupta, if your argument was taken on face value that it has to a new plaintiff or defendant, then substituted would not come in. Then it would be added. The new is not as new as it seems.
Here, the
Substituted or added takes care of that.
would mean that the heirs of the original who was there, here the original is not there.
Yes.
So substitution cannot be of somebody who is not there. It is only addition.
Let us move away from 21 now. I've got it.
I was hoping that your lordship would move away from 21. Nonetheless, in the next
Yes.
point.
21 is over.
Yes. But the next point is
Yes.
that non-joinder of a necessary party is not curable after limitation. Your lordship had in the judgment had said that it is curable. In paragraph 25.
One other premise was there in the order under review. That was that the estate basically was something of that sort. Estate was already represented by the other judgment debtors.
Yes.
It's non-segregable.
Yes.
If the award is non-segregable between the award debtors, and if some of them are parties, then what we do is we add parties. I mean, the estate was represented, the estate of the judgment debtor, the award debtors. If that was represented, the execution case is not barred as a whole. So if those people are brought in later, some of the joint tenants are left out in an eviction suit. Subsequently, the estate is represented. The decree is not vitiated by non-implement of those people. They can be brought in later.
But here, possibly, it's not a case of a joint tenant occupying the same board.
Not joint
Here-
tenant. It's a
here
bad
is-
example, but
Uh,
analogy, because one of the paragraphs of the order under review says that the interest is not segregable.
it is on the basis of that paragraph that I say that made the deceased judgment debtor a necessary party, and non-joinder of necessary party warranted dismissal.
All right.
So, I am relying on your lordship's finding in saying that there was a necessary party was not joined. So, that provision of order 1 for non-joinder of necessary party would come. Now, one other thing that I need to also indicate that the death was also published. That is at page 65.
Publication I won't look into. That's a new factual
Well,
issue you are raising in review. No, it was not before the court.
It's only to countenance the good faith issue. Though I need not
Court
travel to the
cannot look
date
into
of-
that. There was a publication. They have a right then to argue that that publication was not proper or whatever. That's a factual issue, new fact, no, available to you at the time of passing of the order. It's not discovery of new material or error apparent, definitely not. We cannot look into that.
But I was only trying to countenance the point of good faith.
Put it in your written notes of argument, but I'll
But
turn it down.
I need not travel that far because he was not made a the date of death is not relevant here.
The original, our data
Original-
itself was very well. I get your point.
That is why I need not possibly.
Right.
Now, if your lordship kindly permits me to place the two judgments which your lordship was pleased to negate on the ground of section 21. The All India Reporter 19, 19 Calcutta, page 510,
Yes.
paragraphs 2 to 4.
What is it?
Paragraph 1. May I,
What is rule made absolute?
paragraph 1 kindly sees this rule was obtained.
One should celebrate the brevity of these judgments, sir. Anyway, yes.
And trace, my lord,
Too good. 4-paragraph judgment lays down the law over.
this rule was obtained by one of the auction purchasers who purchased the property of the judgment debtor at a sale in execution. Calling upon the opposite party, the judgment debtor to show cause as to why the judgment order should not be set aside. The facts were perfectly simple. Certain property of the judgment debtor was offered for sale and was purchased by the two persons. The sale took place on such and such. On such and such, judgment debtor made an application under provisions of Order 21, Rule 90 to have the sale set aside. To that application, he only made one of the auction purchasers a party. On 8th October 1971, the other auction purchaser was added as a party. It is a common, 1917 it should be, it is a common ground that it was beyond the time fixed by the Limitation Act for making the other auction purchaser a party. The question that we have to now decide is whether both the auction purchaser were necessary parties to the application. It is said that they were not in, and reliance placed on a decision of the court and section 311 of the earlier series to show that it was not necessary to report it. The decision relied upon is the case of Surendra Mohini Devi versus such and such. It will be noticed that in another case reported in the same volume, namely Menajuddi Biswas versus Tom Mondal, it was held that the auction purchaser was not a necessary party to a proceeding for setting aside a sale, and therefore the court relied upon another decision, namely the decision in the case of such and such, which is an authority to the effect. However, we are not now considering the case of order of the Code of 1882, but under the present Code of Civil Procedure. It is quite clear that under the present code, the auction purchaser is a necessary party. It is only necessary to refer to the proviso to Order 21, Rule 92, Sub Rule 2, to show that it is quite clear that the auction purchaser must be a party to the application. That being so, the judge has no jurisdiction to hear the case. One of the auction purchasers not being a party and not being added until the expiration of the period fixed by law for making auction purchaser party. Therefore, we make the rule absolute and set aside the judgment and the order passed by the learned decision. So, post expiry of limitation, this was not. Yeah. There is one other judgment, my lord, which I said. This is All India Reporter 1960 Madras 134. Paragraph 8, my lord, if your lordship is pleased to take a look at it.
This was considered by me previously.
Yes, all three sides.
All three.
Yes. Yes, Mr. Gupta.
Yes, paragraph 8, my lord, in the second page. This suit was filed on such and such on the date. Such and such was not on record as defendant. On objections raised by the defendants, he was brought on record as a sixth defendant on such and such 1954. And as per, there is no dispute that if the date 10/7/1954 has to be taken as on the date, as the date for calculating the limitation period, then the suit will be plainly barred. Both courts below held that the suit was barred by limitation. Hence, this second appeal by the defeated plaintiff. The short point for determination in this second appeal is whether by reason of such and such not being on record when the suit for dissolution of partnership and taking of accounts was filed, it is bound to fail as being barred by limitation. Because if the date on which such and such was brought on record, 1954, is to be taken as the date of institution of the suit, then it will plainly make the suit being instituted far beyond the 3-year period. Then, Malad, the next then, Malad, the other one which I had placed, which is also referred to in the impugned order.
No, this was the argument. This was the narration of fact. What is the ratio of the judgment? Madras? Anyway, the second appeal was
Paragraph
dismissed.
20, yeah, second appeal was dismissed. Paragraph 24, 5, 23 to 25.
Yes. This was not specifically dealt
Paragraph
with.
24. 24, it says that it was not brought within 3 years from the date of death of such and such. Relying on this judgment, net result of the analysis is that the second appeal is bound to fail and is
There
dismissed.
is no independent ratio in this judgment, with utmost respect. Quote several judgments, whatever has been argued. What is the ratio of this judgment? Neither any descriptive ratio nor any prescriptive ratio. No general principle of law laid down or relied on, nor application of that general principle has been considered here. Anyway, we'll take this judgment. Yes.
And this was the last one which was referred, Malad.
You have handed over.
Yeah, I'm sorry. Please.
This is 32 Madras.
32 Madras.
Yes.
Paragraphs 21 and 22. Now, this judgment was on section 22, where your lordship had distinguished on the point that
21.
22 did not have the proviso.
So therefore,
So I am not really, but I just because I had placed these three,
okay,
but I'm
okay.
and the only last judgment which I shall place is, Manoj, this is a new judgment. 2022 SCC online SC 1307. 18, Manoj, if your lordship is pleased. Paragraph 18 to 27. This lays down the test of a necessary party. Because I say that the necessary party was not joined, so it should be dismissed. The entire thing goes for that. It could thus be seen that a necessary party is a person who ought to have been joined as a party and in whose absence no effective decree could have been passed at all. It has been held that if a necessary party is not included, the suit itself is liable to be. As already discussed above, the plaintiff himself was admitted, but I am not placing this. Paragraph 20. It can thus be seen that what has been held by this court is that for being a necessary party, the twin tests have to be satisfied. The first one is that there must be a right to some relief against such party in respect of controversy involved in the proceedings. The second one is that no effective decree can be passed in the absence of such a party. In view of the plaintiff's own admission that the suit property was jointly owned by the defendant, his wife and 3 sons, no effective decree could have been passed in their absence. So, Manoj, here is a case of joint, without whom no effective execution can be done. So, the execution case did not have necessary parties, so the execution should be dismissed. Those are answers.
yes. That's it.
This is on. This is a judgment report at All India Reporter 1969, Bombay, page 84.
You have covered all the chartered high courts.
I'm sorry, Manoj.
You have covered all the chartered high courts. Rightly so. Why not? Yes.
15, paragraph 15, Manoj. Firstly, before this court, and secondly, it's a review. So we had to try and do more than what.
I'll respond to this outside the court. That firstly, to the first submission. That firstly, it's this code. Yes. Para 15.
Always in code 16 we were.
You'll get a good spanking from me somewhere. Yes. Para 15, please. Yes.
The legal representatives of the deceased judgment number 2, Vijay Shankar, object to the application on the ground that the execution application is time barred against them. The present execution application was filed on such and such. In the application, execution was sought against the deceased judgment number 2, Vijay Shankar. He died on 31st July 1959. The execution application was therefore filed against a dead person. But only difference is it was not filed at all.
Only difference was he was alive. This, your Aditya was alive at that. No, when the execution case was filed, he was not alive.
He was not alive. He passed away in 2014.
All right.
And in my opinion and nullity, so far as the said judgment letter was concerned, it has been held in case of such and such that an application according to by a chamber order date such and such, the legal representatives were joined. In any case, the execution application against them could only be deemed to have been filed in on that day. This date was beyond the period of 12 years of the passing of the decree. In my opinion, the execution application is barred by Article 136 of the Limitation Act insofar as the legal.
This was for an application for bringing them on record. It's precisely the same.
Yes. But the only difference is that here, against the deceased, it was filed, but here, it was not even made a party. This is the closest which we could get.
Yes, yes, it's very close.
Those are my submissions. May I file the affidavit, sir?
Yes. Yes, so we can start today. Yes.
I don't know whether Lordship is hearing the appeal or the review, my lord.
I also don't know.
Well, that's the real confusing part, my lord.
No, but
My lord, I may make a mistake, my lord, in making my submission.
Yes.
Kindly have a look at my lord order 47 once. The scope of review. That's very important.
Yes.
Lordship, I need not trouble your lordship.
Every day you read out to me.
Now, my lord, few authorities on this. These things, my lord, he cannot argue or agitate. In a review petition, the provision is appeal. Maybe a clause 15 appeal, maybe go to higher forum, or maybe order 43, whatever way. Can't be argued in a review petition reopening the issue. Scope is very limited. Discovery of new facts, due diligence, and for other reasons. All have been explained by Supreme Court, my lord. Kindly have a look at, my lord, one judgment on this. 2021, volume 13, Supreme Court cases.
Have you got extra copies?
Yes, yes, I have. I have. I will also argue on merits since he has argued order 1, rule 10 and section 21. Now, my lord, the complete answer, just slightly, my lord, deviating. Execution, my lord, is a continuation. It's a part of my lord's suit, my lord. And I will argue on that. 2021, volume 13, Supreme Court cases, page 1, my lord. Scope of review. My lord, relevant paragraphs, if lordship, my lord, kindly takes note of.
Yes.
There, my lord, High Court allowed the review. Supreme Court set it aside, my lord. Paragraphs 2, 5, 2.6, 2.7, 2.8. Paragraphs, my lord, then 7, 19 to 15.
19
to 15.
19 to 50.
9 to 15. Sorry, 9 to 15. I'm sorry. 9 to 15.
Yes. You said paragraph 2.
Paragraph 2, then 2. Paragraph 2.
Then 2.5.
Sorry, yes.
Very good.
And paragraph, my lord, 5 also. Facts, my lord, I am not placing before your lordship. There, my lord, in a first appeal, an amendment application was filed, my lord. Amendment was allowed. Then, my lord, first appeal dismissed. Now, with regard to a certain observation made in the amendment application, a party sought review, my lord, which was allowed. Challenge in Supreme Court. Supreme Court said, no, review is not permissible. Now, why, my lord? While holding this, Supreme Court, my lord, Honorable Supreme Court has referred to, my lord, several decisions, my lord. Kindly, my lord, comes to paragraph 7 onwards. I need not trouble your lordship all the decisions, but two judgments are very important in this, my lord. One is 7.1, that is, my lord, 2006 volume 4 Supreme Court cases 7-8 that has been quoted here also, paragraph 7.1. It says, my lord, quoting that judgment in a particular paragraph, it is well settled that the review proceedings are not by way of an appeal and have to be strictly confined to the scope and ambit of Order 47, Rule 1.
Mr. Devi need not read the entire judgment.
Very
on
well.
review.
Then, my lord,
Review
kindly, my lord, comes to
scope is
my lord,
now well settled.
yes,
Unless it
now, my lord,
something
kindly, my
different
lord,
from
comes to
Yes.
kindly, my lord, comes to my lord, page, my lord, 25. Quoting to an earlier Supreme Court decision, my lord, the principles have been, my lord, called out, my lord. Kindly, my lord, consider this, my lord. This related to, my lord, Administrative Tribunal Act. I am carrying that book, my lord. What does it say, my lord? Just, my lord, may I, my lord, read it out, this, my lord, particular thing. The power of the tribunal to review its order and decision under section of the Act means the Administrative Tribunal Act, is akin and analogous to the power of Civil Procedure Code under section 114 read with Order 47 Rule 1. The tribunal can review this on other grounds enumerated in Order 47 Rule 1 and not otherwise. The expression any other sufficient reasons appearing in Order 47 Rule 1 has to be interpreted in the light of other specified grounds. So this has to be read with the other two, my lord. An error which is not self-evident and which can be discovered by long process of reasoning cannot be treated as an error on the face of the record, justifying exercise of power under review. So error has to be absolutely on the face of it. If you try to argue and establish an error by placing the case in detail, then the provision is appeal, not the review. It's as simple as that, my lord. Then, my lord, paragraph 10. The final finding of the Supreme Court, after relying on several authorities, my lord, to appreciate the scope of review, it would be proper for this court to discuss the object and ambit of section 114 of CPC as the same is substantive provision for review. When a person considering himself aggrieved either by a decree or by a court from which an appeal is allowed, but no appeal is preferred, but there is a provision for appeal for an order and decree may apply for it. That's they have quoted, my lord. From the bare reading of section 114 of CPC, it appears that the said substantive power of review under section 114 has not laid down any condition as the condition present in exercise of the powers for review, nor the said section impose any prohibition on the court for exercising its power to review decision. However, an order can be reviewed by the court only on the prescribed grounds mentioned in Order 47 Rule 1. Then, my lord, I need not trouble your lordship. My lord, powers of review, same paragraph, last sentence, the powers of review cannot be exercised an inherent power, nor can an appellate power be exercised in the guise of power of review. So it can't be done. Straightway, simply, it's barred. What they have argued, my lord, on merit. And finally, this court, my lord, allowed the review. Sorry, my lord, Supreme Court said to decide the review or order allowing review, my lord. This is one, my lord. Now, my lord, there is another judgment, my lord, lordship can consider, my lord, on this maintainable review. That is, my lord, 2006, Volume 1, Supreme Court Cases 509. Re-arguing a case, sorry, in a review petition, my lord, is not permissible. It's barred, clearly barred. Kindly comes to, my lord, paragraph 12. 12. Paragraph 12. I'm not placing the facts, my lord, in detail, my lord.
We'll have to continue with this.
Yes, yes, my lord, I will.
I have to rise early for some
Absolutely, my
pressing
lord.
business.
I will only take 10 minutes, my lord, on facts, my lord, what he has argued.
Hard in part for further hearing on January 10, 2025.
Lordship.
I'm sorry I have to rise early
No, my
today.
lord.
Next
Then,
Friday.
my lord, may I, my lord,
Affidavit is satisfied today.
Lord, may I, my lord, take back the last one which I cited? Lordship has noted it, my lord.
No.
Then, my lord, I can take it and place it on the next day. If Lordship wants, or Lordship
I
can
can
keep
note
it in
Let it be
very
there.
well, very well.
Remind me it is there. সবটা
Very
একসঙ্গে punch করে রেখে দিন।